on behalf of the appellant, Ms. Wardlow. I'd like to begin by pointing out that last January, I filed a notice of supplemental authority attaching the Dumigan versus Holmes regional decision. That decision is now final and is reported at 332 Southern 3rd, 579. That case makes it clear that Mr. Zubas's opinions, his expert opinions, do not constitute a stacking of inferences.
Well, we'll allow you to make that argument during the course of the presentation. Right now, I want to make sure that I have all the attorneys present. It appears that I do. Mr. Bilecki, you will be going first, is my understanding, and then Mr. North?
Yes, Your Honor, and
it's 10 apiece?
Yes.
Okay, so I should give you kind of a warrant now. Are you reserving any time for rebuttal?
Just a minute or two should be sufficient.
Okay, from whose time do I deduct, say, 2 minutes?
Well, my presentation, you've already heard half of it.
Oh, okay.
I would intend to spend the majority of my time responding to questions or concerns of the court after a brief summary of our position.
Then I will divide your time as 8 and 2. I'll do your 8, then I'll go to Mr. North for 10. Then I will stop, reserving 2 minutes for rebuttal. Mr. Perkins, my understanding is you have 15 and you, Mr. Lugo, has agreed to 5. Is that correct?
That's correct, Your Honor.
Your Honor, sorry.
Yes, sir.
I intended to reserve 1 minute of rebuttal myself.
Okay, thank you. I will then let you know at 9.
Thank you.
Okay. Okay, so then Mr. Perkins, will you be the lead first and then Mr. Lugo, or will Mr. Lugo go first?
I'll go first.
Okay. Feel like an air traffic controller right now. I think I have it all set, and I have my clock here. All right. So with that said, I think I am ready for Mr. Bilecki, and I will let you know when you get to 8 minutes.
Thank you, Your Honor. Let me start over. May it please the court, Jim Bilecki on behalf of Ms. Wardlow. Last January, I filed a notice of supplemental authority attaching the Dumigan versus Holmes regional decision. That case is now final and reported at 332 Southern 3rd, 579. And as that case makes clear, that Mr. Zubas's opinions aren't subject to or considered stacking of inferences. The cases from this court that compel reversal are Hughes versus Slomka, Martinez versus Lobster House, and Clark versus Polk County. I know there are other second district decisions cited in my briefs, but those 3 are the key cases that compel reversal. 2 cases from the Florida Supreme Court, Sanders versus ERP, and Orlando versus Executive Park in particular, and that I'm including the district court decision as it's quoted in the briefs. Also, Castillo versus EI DuPont is a Supreme Court case that addresses and explains that when the facts support more than one reasonable inference, it's the jury, not the judge, that evaluates which of the inferences is more persuasive. I've cited many district court decisions in the briefs dealing with parking lot security and the either denial or reversal of summary judgments and directed verdicts. The one case that I would specifically rely on is the Salerno versus Hart Finance decision out of the 4th District. That's a case that involved what one might call a targeted crime. And the Fourth District held that the combination of the facts and the expert testimony on causation made direction of a verdict error. And as I point out in my initial brief, I don't need to or want to get into a discussion about the change in the summary judgment rules. Under the federal case law interpretation, a summary judgment is treated similar to a directed verdict, and I rely on the directed verdict decisions and the burdens associated with that. I know Slomka, Hughes versus Slomka is one of the cases that spells that out. And I think the USAA case out of this court also spells that out. And what I'd like to do is reserve 1 or 2 minutes for rebuttal and devote my time to responding to any questions or concerns of the court. I see this as a straightforward issue, an appeal, and if I'm missing something that I've overlooked and it is a question or concern of the court, I'd like to address those at this time.
With regard to the evidence, there is a concern that this is a targeted shooting. And normally it's my understanding that in terms of liability, one oftentimes looks to the control of the premises. Does the fact that this is a targeted victim, if you will, change the analysis in some way?
No, it is, it may influence both the persuasiveness of the evidence. I think that you will find in the case law, I forget, I've lost track of the case. I think it's the Naked Truth decision. I don't know if it's been cited by either side, but in that case, there were competing expert testimony on the effect of targeting, whether not a targeted crime is more difficult to prevent or deter. But that's a difference in degree, not in kind. I've string cited a number of targeted crime cases at pages 12 and 13 of my initial brief. And in looking at it, I see that I did cite the Naked Truth decision. Vasquez was a targeted crime where a victim was targeted by her husband. The LB versus Naked Truth was a clerk targeted by a customer. And then the Salerno case, which I consider to be the most persuasive, is Salerno versus Hart Finance, where one tenant in a mobile home park attacked other tenants. And the testimony in that case was that the crime would not even have been attempted had the requisite security been in place. So to answer your question, it's a matter of degree, not a difference in kind.
Let me ask one question as to the expert opinion that you offered. The expert had said if there were security cameras and security guards, then it is more likely than not or reasonable to believe that the crime would not have occurred. But in fact, there was surveillance video, wasn't there?
I believe there was. I don't know that was ever.
So how does his expert opinion relies on what additional efforts might have been taken to provide security at the premises, but I'm not quite sure I appreciate the argument that this isn't purely speculative. I mean, one of the things he said is, well, more video cameras or a video camera would have, security cameras would have scared off a potential perpetrator, but there is a video camera here. And we know that because the record talks about what the surveillance video shows. There was a security guard who happened to be inside, but this is also a large property. So even if there was a security guard dedicated to the outside, isn't it speculative that the perpetrators would have even seen that security guard, would have reacted to it? The security guard might have been helping someone find a car, might have been helping someone get their car jump started. So I'm troubled by how much speculation seems to be involved in the expert's opinion.
I don't believe there's any testimony one way or another as to the source of the surveillance. I don't recall where that came from. I don't think there's any testimony or discussion of whether those security cameras are visible or hidden, or where that it was located. But as a member of the jury, you certainly could discount the effectiveness or the need for additional security, but that doesn't take away from the overall opinion that one guard was clearly inadequate, and that's demonstrated by the fact that there was only one guard for a very large property and who couldn't be in all places at all times. So
Let me phrase the question differently, and perhaps you can tell me where this concern would be placed on the analytical framework, or whether it's just a jury question.
well, I think
Reviewing the materials that you guys have presented to us here, I could not help but recall the time when I used to ride with law enforcement officers either in Fort Myers or Lee County when I was an assistant state attorney. And I remember the type of weaponry the Leos carried. Right, so we're talking about an off-duty officer or a security guard with, even if they were there, how would their armament match up to gentlemen with an automatic weapon? You know, and now this may not fit in anywhere, but you know, we're talking about deterrence or stopping the crime. Are we expecting a non-certified Leo with maybe a taser to step out and stop these guys? We expecting a Leo off duty to step out with a pistol? I mean, what type of armament would have to be supplied in order to deter a crime of this magnitude? Or does it not explored in our record? And by the way, I know you're almost out of time, but don't worry. I got a few minutes extra and I'm sitting center chair, so I think we can get your answer.
well, I appreciate the opportunity to respond. The expert opinion, and while I won't concede it as a matter of fact or as a matter of law, the presence or absence of surveillance is not the key issue in this case. The key issue is the failure to have multiple officers patrolling, but also a visible presence with a police vehicle. And the facts in this case are set out in the—
When you say a police vehicle, were you talking Lee County Sheriff's Office vehicle, or are we talking a mall security vehicle?
No, he was talking law enforcement vehicle, not a private security. And that's
So,
done.
does our record tell us whether the Lee County Sheriff's Office lets off-duty officers use a departmental vehicle for their private, contract work?
I don't know that it's discussed either way in the record, but
Okay, I just want to make sure if I missed it or not.
if that were a critical fact, that's something that should have been brought to the, placed in the motion and addressed. And regardless, and again, the case law that has been cited, we don't have to prove each and every possible security measure, or prove that each and every security measure would have 100% in fact deterred or prevented this incident.
Okay. Let me stop you there so I can preserve your 2 minutes, because we're well past 8. And let me turn now to Mr. North. If you will hold on, Mr. North, so I stop my time clock so I don't go into your time before you start. And I've done my engineering skills. Mr. North, you may start.
Thank you, Chief Justice, and may it please the court.
No, I'm only the center chair. My term as chief judge expired about 10 years ago. I may be the chief of this panel, and I appreciate the comment, but I don't want to lure you into a bad habit with other members of our panel. We have one chief judge. He's not on this panel. And the only reason I'm sitting center chair is I'm the longest serving member of the court, which means I'm one of the old timers.
Well,
You may go ahead,
Justice.
Mr. North.
Thank you, Justice. I represent the estate of Kevin Robinson, the estate of Javarshi Riggins, and Ms. Ksenia Kryliak. This court should reverse the holding of the trial court for 3 reasons. First, expert testimony constitutes direct evidence and is not within the narrow prohibition against inference stacking. This court has recognized that expert testimony constitutes direct evidence not only in negligence cases, but specifically on the issue of causation, and has found that where expert testimony is presented on point with regard to the issue of causation, no further evidence is required. And as far as the expert testimony in this case, Mr. Zuvis has provided testimony that has gone in large part unrefuted. Mr. Zuvis is a negligent security and crime prevention expert and testified specifically to, quote, if Bell Tower had implemented adequate standards and security measures, it is more likely than not that assailants would have been deterred, thus preventing this crime. He testified that the appellee's failure to have reasonable security measures in place at the time of the shooting more likely than not contributed to the shooting. And he testified to these findings all within a reasonable degree of professional certainty.
Let me ask you a question. I think that pertains to your second argument, and I'm trying to make sure I know where to place it on the analytical line, whether it's part of a legal matter that the court gets to review de novo, or whether it's a concern that goes to the jury in weighing all the evidence. And that is this. Normally, we deal with the average run-of-the-mill, I shouldn't say the average perpetrator, okay? This seems to be different than an average person who might be deterred. It's almost like this was a contract hit. I mean, if you grew up in Tampa, maybe in the other places in New York, you're aware of contract hits in the underworld. I think that's the term they use. If we assume that this is a nature of a different type of event, that is automatic weapons, someone trying to take this gentleman out, the primary person, does it change our analysis, or do we stay with the normal kind of stuff, particularly where you don't know who the hit people were in this case because they've never been caught? And so I know sometimes the average person may be deterred. Does it change at all if it appears to be analytically different? And I don't want to use up any more time, but I think that's the end. That's my concern.
No, Your Honor, it doesn't change the course analysis. That is something for the jury to consider when determining the extent to which a crime could have been deterred or prevented as far as the reasonable security measures are concerned.
So that would be a causation analysis by the jury?
Correct.
Whether these things would have impacted this case or not?
Correct. It would be an issue of fact for the jury to decide. And that is why at the end of the day, the motion for summary judgment should be denied, because the jury has, appellants have presented adequate testimony or adequate evidence on the causation issue. And as far as inferences are concerned, the jury wouldn't have to make any inferences or stack any inferences. Rather, they would have to take expert testimony that's gone unrefuted at face value. And as far as Judge Silverman's concerns regarding whether the testimony has been based on speculation or assumption, Mr. Zuvis relied on a number of facts specifically pertaining to this case and the property at issue, as far as reviewing past incident reports, police reports, conducting his own site inspection, conducting a security risk assessment based on the size of the property, the areas of access. He reviewed testimony from the appellees and their security providers, and those are what form the basis for his ultimate conclusion, which is that the appellee's breach of their duty to provide adequate security caused the shooting on October 9, 2018. And to the extent Mr. Zuvis relied upon any inferences or assumptions, to the extent any inferences and assumptions should affect the value of his testimony, that is for the jury to decide. And this court has always recognized that experts are allowed to make some inferences and some assumptions in arriving at an ultimate conclusion. The second issue I want to address is that Ms. Kryliak, who suffered emotional and psychological damages, is able to recover her psychological and emotional damages under the impact rule. Now, the impact rule in negligent cases states that in order for a plaintiff to recover for psychological and emotional damages, they must suffer a physical impact. And in this case, when Ms. Kriliak heard the dozens of rounds being fired from automatic weapons, she ran and dove to the ground to avoid being hit. When she hit the ground, she suffered multiple physical injuries in the form of cuts, bruises, open wounds, eventual infections, actually. And those were to her legs, knees, her back, her elbow, and her hands as well. And that is the exact type of physical impact that Florida courts recognize as actionable as far as opening the gates for emotional damages and psychological damages being recoverable. The Florida Supreme Court stated in Willis versus Gammy Golden Glades that the plaintiff must meet, quote, slight requirements, and that the essence of impact can be large or small. It can be visible or invisible. And there's actually a case out of the 3rd District titled Lloyd versus Cal Covens Construction, in which a plaintiff who was in a similar predicament as Ms. Kriliak suffered injuries to his knee as he was avoiding greater contact from a car that was out of control. And when he dove out of the way, he suffered impact to his knee as he fell into a stony area. And the knee injury he sustained was sufficient as far as the physical impact needed to open the gate for emotional and psychological damages. So in this case, Ms. Kriliak, based on her physical impact that she suffered that night, is allowed to recover for her psychological damages, which have manifested in the way of nightmares, trauma, going to therapy. She's been prescribed psychological medication, and she has PTSD every time she hears popping or loud sounds. And I'd also like to bring up briefly that the trial court erred when it granted motion for summary judgment under the stricter amended summary judgment standard. The Supreme Court issued an opinion in which it is clear when the pre-amendment summary judgment standard applies. It stated, any pending rehearing of a summary judgment motion decided under the pre-amended rule should be decided once again under the pre-amendment rule unless a party files a renewed motion for summary judgment. In this case, the appellees did not file any renewed motion for summary judgment. There was not any other motion for summary judgment filed at all. The only thing that was filed were a number of notices of hearing. So this is clearly a case where you have a motion that was decided, pre-2021 under the old rule, and then was, after a couple of notices of hearing, eventually reheard. And so because it was reheard, it was inappropriate, for the trial court to apply the amended version and actually weigh the evidence. But please allow my position to be clear, and that is that the appellants, is that the motion for summary judgment should be denied regardless of which standard applies. And that is because even if there is a weighing of evidence, of course, all inferences are in favor of the non-moving party. And here on the issue of causation specifically, appellants have met their duty of providing a prima facie case, specifically as it relates to causation, because there is expert testimony that is directly on point based on facts in the record, based on Mr. Zuvis's unimpeached qualifications as it relates to causation.
Mr. North, I have one question about his opinion. When I read it, I don't recall him addressing in any way the fact that this appears to have been a targeted shooting. Am I missing anything from his analysis, from his opinion? And 2, if he did not address that, does that make a difference?
Your Honor, I don't believe you're missing anything, but the way he addressed it is essentially by making the assumption that most crimes are deterrable. And I know that was an issue of contention in appellee's brief. And in finding most crimes are deterrable, what Mr. Zuvis is testifying to is that most criminals at the end of the day don't want to be caught. And that's where reasonable security measures come into place. And as far as I know, there were questions when Mr. Blecky was speaking regarding what sort of artillery or armor would be necessary. It's not about the armor, it's about the presence. Because if there's an adequate and reasonable security presence on the property, then whether a shooting is targeted or not, assailants aren't going to attempt to commit a crime in the face of a Lee County Sheriff's Office vehicle, security cameras that are in the parking lot, and to the issue of security cameras spoken to before. My understanding is that there were cameras on the property. However, there were no cameras in the parking lot where much of the shooting actually occurred. And so these are the sort of security measures that prevent and deter crimes from occurring, and would have deterred a crime from occurring on October 9, 2018. And unless the panel has any questions for me, I've provided the reasons why, in appellant's opinion, the court should reverse the decision of the trial court.
Thank you, counsel. We have I also saved your 1 minute, so that's good too. I thank you. Let me clear the clock here. Alrighty. Mr. Perkins, I believe you were going to go first, sir.
Yes, may it please the court. My name is Brandon Perkins. I represent the Bell Tower. The issue in this case is causation is based on pure speculation. Mr. Zuvis had an opinion that he says it's more likely than less likely that if adequate security measures were in place, this crime would be deterred. But when pressed as to what that means and what facts he was utilizing, and I would direct the court to page 74 and 75 of his deposition, Mr. Zuvis provided a tautology. He simply said, well, most criminals don't want to get caught. Most crimes are deterred by adequate security measures. A crime occurred here, ergo, if there was adequate security measures, the crime would have been deterred. He could use that tautology in any case. And essentially he's saying, if there's a crime, then we know that according to him, there's inadequate security. And we know that if there was something else, that it could be deterred. When you parse his words, when he's, and I tried my best during his deposition to pin him down, it's clear that what he's talking about is if you have more security measures, so you have 100 cameras, 100 security guards, 100 locks, 100 gates, then you're going to have less crime rather than more crime. So if you have less security measures, you're going to have more crime than less crime. This is like a common sense sage advice, okay? It has nothing to do with this particular case and whether this particular crime was more likely than not deterrable. And we know it even more because I pressed him, statistically would this be deterrable? And he said, well, it could be 10%, 20%, 50%. I can't give you a percentage. And so when asked, like, all he needed to say, if his opinion was that it's more than 50% likely that this crime wouldn't have occurred if we had more security measures, he could have said that. But in fact, he said the opposite. He said he couldn't give a number on it. And so what the plaintiffs are asking this court to do is to say, this should be a jury question, even though our own expert couldn't give a probability of greater than 50% of this crime being deterred. I asked Mr. Zuvis time and time again what facts he was looking at to come up with his analysis. And he said, I'll say it again. I've said it in other cases. I've looked right at juries and said this. Most crimes are deterred by adequate security measures. He wouldn't pin down, I looked at the nature of this crime. I looked at, how this crime was committed. I looked at how long the assailants were on the property. He admits nobody knows how long the assailants were on the property. Nobody knows where the hypothetical off-duty police officers would be, except for we know that according to Mr. Zuvis, one would have been inside the mall, so that off-duty officer wouldn't, be effective at deterring this crime, and one would be patrolling the outside of a 9-acre mall. Well, if you look at the layout of the mall, there's parking lots surrounding it. There's a movie theater on the other side of where this occurred. So obviously the officer could be attending a problem over there. We just don't know where this off-duty officer would have been. Now, there are cases, and Mr. Blecky brought up Salerno. That was a tenant interaction, inadequate security. But you look at a case like Salerno, the tenant who's in the park, they know what security is available and what security is not available. And so we don't know whether these unknown assailants knew whether there was off-duty police officers at the bell tower at the time or not. We just don't know. And Mr. Zuvis, he says, well, most criminals case the joint before they commit their crime. But when pressed, do you have any facts that these criminals, cased bell tower before they committed their crime? He admits, I don't know. So you end up having to stack inferences in order to reach a conjecture that there was causation. And Mr. Zuvis could not give a statistical probability of causation, and the jury can't either. So the trial court was correct in determining that there was no evidence of causation. And to the point of it being a targeted shooting, it does matter, because when we look at causation, we look at things like, could a reasonable jury determine that there was causation under the facts of this case? And when you have automatic weapons, 60 rounds fired, Mr. Riggins running from the guns, the assailants chasing Mr. Riggins until he was finally shot and succumbed to his injuries, and then immediately retreating, all of the evidence points in one direction. This was an assassination. And then when you look at other pieces of evidence, you find out that in the years leading up to this, every year, Mr. Riggins was either shot at, was shooting at somebody, or was in prison. The only years that he wasn't shot at or shooting somebody, he was in Florida State Prison. So there's no evidence that this was a crime of opportunity where, a person got their purse snatched and there was inadequate lighting or something like that. No evidence that a jury could really rely on to determine that this could somehow be deterred or prevented. And even Mr. Zuvis admits that, intentional murder is something that is, very difficult to prevent. To Ms. Kryliak's claim, the Florida has the impact rule for a reason. It's adhered to it. The reason is to weed out claims of fraud. Anybody can say, oh, I'm emotionally, impacted by, a tort. And so we require some sort of impact. It doesn't have to be much. The Florida Supreme Court in Willis said, putting the gun to the temple of somebody's head is sufficient impact. We have cases where smoke is enough impact. But all of those cases, the person impacted was within a close proximity zone of risk of being, injured. Here, Ms. Kryliak was in a building upstairs, not near the parking lot, and she heard the gunshots. So if you extend the impact rule to somebody who crawled on her hands and knees and had knees bruised from doing so, that was far removed from the parking lot, what essentially will happen
Is it a fair concern in considering this claim that we're not talking about a car rolling over or someone driving by? We're talking about a projectile shot from an automatic weapon, multiples. Isn't that reason to say that there's the impact is there by the sound and the travel of the bullets, or do you have to stand in front of it to get hit in order to have an impact rule? I suspect getting hit by AK-47, if that's what that weapon was, might be rather fatal, and it might be prudent to dive for the ground.
I think the difference is if you're going to extend this impact rule to anybody within earshot of a gun because a bullet can travel.
Well, this is a little bit different than merely hearing it. It's in the parking lot, just across a narrow travel lane?
Well, so the travel lane.
Maybe I should be more precise. Does our record tell us how far from the shooting she was when she dove?
So there's a picture of the layout. She's in a place called Society, and so you have the shooting that occurred in the parking lot. You have a frontage road. Then you have TGI Fridays, that building, and then next to behind TGI Fridays you have Society, and upstairs in Society is where Miss Kryliak was at, and so. She's protected.
That would be the picture attached to the summary judgment motion of the location?
Yes.
Okay. Yeah, I have that.
And
I
so,
can't put my fingers on it. Oh, there it is. Okay.
I
didn't print color, but yes, got it.
I appreciate your honor's point. And, you know, if she was in the parking lot, say, even in a car or in a building next to a window, you know,
So what you have is the parking lot, the car lane, the TGI Fridays, kind of a walking area, and then you get back to society. Is that the right? If I'm going, I don't know which direction that would be. You know, on my sheet of paper, it would be west, I guess, if north is top. Okay,
that's
gotcha.
correct. And, you know, unless the court has any questions for me, I'd like to turn it over to Mr. Lugo to see if he has additional arguments to make.
Mr. Perkins, I want to explore that last issue just a little bit more. The problem with bullets and diagrams of the parking lot and the shopping center and the mall is if you're inside and you don't see the shooter, you don't know where the bullets are coming from or where they're going to. Isn't that right?
Absolutely. I would.
And so isn't that then a question in terms of whether the plaintiff acted reasonably in diving for cover and the other plaintiff's reactions? Wouldn't that all be a question for the jury?
I respectfully disagree. I think that it's a question for the court on whether she's within a zone that the court's going to find that she's there. If you go back to, say, Paul's graph, part of the discussion between Justice Cardozo and Justice Anderson, it talks about somebody in a second floor window and a car accident. You know, we're dealing with a similar situation. At some point, the court's just got to draw a line as a matter of law and say you're far enough removed. But I appreciate your point.
Thank you, Mr. Perkins.
Okay, Mr. Lugo, I believe the floor for a short period of time will be yours.
Yeah, may it please the court. My name is Ezekiel Lugo and I represent Appalachia Madison Market Real Estate Services, LLC. Our position is that the court should affirm for all the reasons that were included in the answer briefs of both Bell Towers and Madison Marquette. We still rely on that. I'm going to focus more on some of the questions and issues that have come up this morning. First of all, the Dumigan case. The Dumigan case doesn't talk about Mr. Suvas and the type of opinion that Mr. Suvas is given in this case. Dumigan fits within a line of cases that
It's a
include
medical malcase with the anesthesiologist. Is that the right one?
I believe so, but it falls into a line of cases that starts with the La Barbera case from the first DCA, I believe in the 60s. That was the case involving the heating furnace and the clogged air pathway. There's a Florida Supreme Court case, Autry. There's a case from this court, Sharts, and then there's this Dumigan case. And these cases stand for the proposition that if an expert is relying on an inference plus direct evidence, direct facts, then the expert can give his or her expert opinion. But if the expert is using a preliminary opinion to bootstrap his ultimate opinion, and you have the sort of tautology that Mr. Perkins referenced, then the expert's testimony is insufficient. And even if it comes into evidence, it cannot support a jury verdict in favor of the plaintiff. Dumigan doesn't apply here because Suvas doesn't fall into the kind of expert testimony there was in La Barbera or in Dumigan. His testimony is based on an underlying opinion that he created based on his own tautology, or there was a reference to a syllogism. It really was not based on the facts of the case. And I'm talking here specifically about his causation opinion. And that's important because he gave several opinions. He had an opinion on duty, he had an opinion on breach, and he also had this opinion on causation. The problem we're dealing here today is his opinion on causation and the facts that he considered and what he relied upon to come up with that opinion. And Judge Silverman, you had a question about, well, did he consider the nature of the particular shooting in this case, that it was a targeted shooting? He was asked a question about that on page 63 of his deposition, and that can be found on page 942 of the record on appeal on the Wardlow appeal. He said he saw no evidence in the entire file that would support characterizing this incident as a targeted shooting. So he completely rejected that evidence. You know, the fact that these individuals were laying an ambush. There was a driver There were two shooters. They got out. They pursued Mr. Riggins. They shot him. As soon as he went down, they turned around, got back in the car, and left. That is evidence of what Judge Casanova described as a hit. There was no dispute that they were using high caliber weapons, automatic weapons. It would be unreasonable to assume or to infer that that sort of organized, premeditated sort of crime would have been deterred by either a police officer, off-duty law enforcement officer with a taser or even a handgun, or by the police car that was referenced today in the oral argument. Just having the police car around doesn't seem reasonable as a deterrent for the type of particular crime that was at issue in this case. Now, Mr. Zuvaz's opinion is based on speculation. As Mr. Perkins alluded, he did say, well, that more likely than not, the crime would have been deterred. But when he was pushed on the factual basis for that opinion, he had nothing. He conceded he did not know who these assailants were. He conceded he didn't talk to them. He did not know if these were the sort of criminals that would be deterred. At the end of the day, he said he could not give a number. If he can't say if this is 10, 40, 50%, then his testimony that this was more likely than not does not mean what is required under the law, that it's at least 51%. And to cross that threshold, that would satisfy the causation requirement in this case. And going back to Judge Casanova, you're right. The nature of the crime matters, and the sort of crime here, like I said, is not the sort that reasonably would be expected to be deterred by the sort of security measures that Mr. Zuvaz was describing, which, as I heard in the—
Well, Mr. Luke, I'm a little concerned. As you pointed out, the issue here is causation.
Right.
And I'm wondering if most of my focus may be on the first part, and that's, can you have a duty to exercise ordinary care, and will that cover you? How does that apply to an extraordinary circumstance? Is that going to be under McLean, something to do with the zone of risk, which may be a duty question? My concern is if that's not preserved for us, I don't want to be like, I'll borrow Mr. Perkins. Justice Cardozo wrote in his book, like a knight errant roaming around the field of battle. So, I mean, we're limited to causation, and I don't know yet where it plugs in, but at least that's some of my thought process.
It is relevant to causation as well, Your Honor. McCain talked about causation depends on the specific facts of the case. The foreseeability analysis as to causation is tied to the specific facts of the case. So the type of shooting at issue here has to be considered. Whether a crime is targeted or not is relevant and has been the basis for summary judgment, at least in the federal courts. There is a case out of the 11th Circuit where there was a targeted incident.
Was it on the naked truth case that, Judge Rothenberg wrote a very interesting dissent on that one, and it may have some light shining on this case, even from the dissent perspective?
Well, my understanding of naked truth is that it said that the fact that it's a targeted crime is not sufficient by itself to automatically, foreclose causation. But that's not, our entire argument is not based on the fact that it was a targeted crime, but that is important. And Mr. Zuvaz, if he was going to render an opinion on causation, he had to take that into account, and he completely discounted it on page 63 of his deposition testimony. And that's important as to his causation opinion and whether it was based on speculation or whether it was based on facts. It was based on speculation here. He was relying on his general opinion that security measures generally prevent crimes. That is not enough to apply to the specific facts of this case and to say whether the crime here at issue would have been deterred. And it was not sufficient to establish causation. And our position is that even if this case had gone to a jury and there'd been a motion for a directed verdict, this would be like the Brower versus Soda case. That was a case on directed verdict where the speculative testimony and the evidence based on the stacking of inferences, even though it came in and even though it went to a jury, it was not sufficient to support that jury verdict, and it ended up in a reversal.
Thank you, counsel. I think I appreciate you answering my questions, and of Correspondingly, I'm glad I let you go long enough so that you too could respond to the questions fully. Let me return now to rebuttal so that I do this, and that means we go to Mr. Blicky. You have 2 minutes left, but you were a little light on your first take, so I'll give you 3.
Thank you very much, Your Honor. I think it needs to be pointed out that the defendants never challenged, questioned Mr. Zuvis's expertise or his opinions at the trial court level. All the arguments against Mr. Zuvis first surfaced in their answer briefs. And his testimony is quoted over 2 pages in my initial brief. And as you will see, Mr. Zuvis on no less than 5 separate occasions testified that this incident more likely than not would have been prevented or deterred with reasonable security. In this case, and it comes straight from the trial court order, this case is where the evidence shows that unknown assailants emerged from a vehicle that was standing in the access road separating the mall's retail stores and restaurants from its parking lot. And they emerged from that car. They were there and waiting for Mr. Riggins. And when he came out of the restaurant, they exited their vehicle and attacked him with assault rifles. The assailants in this case selected the bell tower shops to assassinate, if you will, Mr. Riggins, because Bell Tower had no security. They sat there unimpeded, they exited their vehicle unimpeded, and whether they shot Mr. Riggins with a slingshot or an AK-47.
Here's just the difficulty I'm having with the argument on this issue. He acknowledges that there are crimes that occur in banks where there are security guards and cameras, and there are crimes that occur in convenience stores where there are lots of cameras, lots of visibility. And he is pressed to go beyond his general opinion as to this case. And I just looked at it again. What percentage would you place on this particular crime being deterrable? I'm not going to place any percentage on this particular crime being preventable. And then he talks about why he can't do that. I'm not sure how we get around that, actually, when he is now saying, here's what happened here. I can't tell you if it was preventable had there been more security.
Well, assigning an exact percentage is not required by the case law. All that's required under Gooding and all of the cases following it is that there be evidence that more likely than not.
But his testimony as to more likely than not is generalized criminal activity. Specifically, this crime, he says he's unwilling to address it.
I don't think anyone can ascribe a particular percentage. He says that this incident, more likely than not, could have been reasonably prevented. And again, this to me is, reflects the fallacy in the targeted crime argument. And that is that if we assume that they were intent on assassinating Mr. Riggins, they selected this property because of the absence of security, and they were able to get away with it without fear of interference or arrest.
But we don't really know that. We don't know that, do we? I mean, you're giving us your theory of the case, which I certainly appreciate, but we don't have evidence that they selected this location to carry out this targeted shooting, or what appears to be a targeted shooting, that's the reason they selected that place.
The reasonable inference from them sitting on premises without detection or deterrence, exiting their vehicle and accomplishing this, they selected it because they apparently knew that Mr. Riggins was going to be at the TGI Fridays. They selected it because they were able to get away with exactly what they did. And whether it's a slingshot or an AK-47, the reasonable inference, and this is what Mr. Zuvis talks about, is that criminals avoid detection and capture, and they are deterrents, and that's what they did in this case. And it's pure jury question. Mr. Zubas's testimony is sufficient to defeat a directed verdict under the Hughes versus Slomka case. He may not have said everything exactly the way one might like, but he said everything he needed to say so that any issues as to his credibility or his persuasiveness are jury issues. And I know I've now used up at least 3 minutes, and I appreciate the court's indulgence and thank you for your patience. And unless there are other questions, I ask that the court, oh, there was one other thing. Let's assume that it was targeted. They would have gone, and had there been a security presence, they would have gone somewhere else and shot him. And if that had happened, Ms. Wardlow would not be injured today. She was an innocent bystander. She was not targeted. She was an innocent bystander to an event that could have been prevented or deterred. And with that,
Thank you, counsel. We'll go to Mr. North. I'll give you 2. Give
Thank
you a
you,
chance to gather your thoughts and hit as many points quickly as you'd like to hit.
Thank you, Your Honor. The issue in this case is whether inadequate security caused the shooting at Bell Tower on October 9th, 2018. And the expert, Mr. Zubas, testified to that specifically. A percentage is not needed. And the basis for his conclusion that adequate security would have deterred and prevented this crime is not based on speculation. He's testified in a deposition transcript that's over 100 pages long, but a few of the things that he relied upon is that the DEGI system on the property was not functioning. The lone security guard did not have any supervision. He relied upon testimony in this case from security administrators regarding the need to increase security before the shooting occurred. And the one sick guard on duty never even heard the bullets. Unlike Ms. Kriliak, he wasn't even within an earshot of the bullets. So in a case where there's no Daubert challenge to Mr. Zubas's expert testimony, it becomes a question of fact for the jury to decide as far as causation is concerned and the weight to give Mr. Zubas's testimony. Thank you.
Thank you. Thank you all for bearing with the panel today and responding to our questions. It's a great help to us, and we thank you. We hope that you all stay well and look forward to the time that we'll all be in the same room together. And with this, I will allow you all to, however you move the microscopic patterns, to return to your electronic place of origin.
Thank you, Your Honor.
Thank you. Okay. And Mr. Blecky, are we able to